So in this video, I want to talk about what we do when we can't match an offer and an acceptance. Remember that when we're thinking about what the elements of a contract are, we are looking for agreement, which usually comprises offer and acceptance. Consideration, which for the time being we're going to refer to as price, intention, and certainty. So right now, if we can't find an offer and an acceptance, is there anything else that we can hang on to for agreement? And then, even though it's a few weeks until we're going to be really doing a deep dive into certainty, how does that impact certainty if we've been working on the basis that everything that we need to know about the agreement itself will be built into the DNA of the offer, and that on acceptance we end up with an agreement? So sometimes we do end up with agreement, spoiler alert, but let's just have a look at how we get there. So as a general principle, acceptance needs to correspond precisely with the offer that's made. This means that an offeree can only accept or reject the terms of the offer, and they can't add anything. If they add something, it's a counteroffer. You understand how that works. However, in complex commercial arrangements, it's not as easy as that. And we often end up with the kind of circumstances that are explained in the Butler and Excello case, which is in your casebook. So that's what we call a battle of the forms case. Effectively, what's happening is both parties have their own documents in place. The buyer presents an order, the seller confirms using its own forms. The terms and conditions might overlap or they might not. In that case, Lord Denning applied what he called a synthesis approach. He described the circumstances of battle of the forms, and I think that's an idea that we can understand. And he said, rather than looking for an offer and acceptance, the better way is to look at all of the documents that pass between the parties and glean from them, or from the conduct of the parties, whether the parties in fact reached a consensus on the material points. Even though there might be differences between the forms, if there is agreement, there is going to be alignment on the material points. And in order to identify that, we're going to have to look at evidence of the ways that the parties interact with each other once the agreement was purportedly made. So ultimately, the test he offered in these situations is asked first, is there agreement? Is there a meeting of the minds? Is there consensus ad idem? And then ask ourselves whether we can see offer and acceptance. And then think about the ways that we need to respond to the contradiction between the standard form contracts. So what's the Australian position? The really important case here is Brambles Holdings and the Bathurst City Council. So that's a case that related to the way an agreement between Brambles for the treatment of waste and the Bathurst City Council. Brambles had already provided services for a period of time and had tended to renew the services. The council had proposed a particular increase in the fee, but also that a certain amount of that should be retained. Brambles, in their correspondence, in a number of occasions said that they couldn't pay that additional amount to the council. That they wouldn't be able to retain it for that purpose, but they did in fact increase the fees, and they did a number of other things to indicate, or that might have indicated to a stranger, an independent person, that they had in fact adopted the terms. Justice Hayden said in relation to this matter, where you can't see a clear offer or an acceptance, it's relevant to ask whether an agreement can be inferred, whether mutual assent has been manifested, and whether a reasonable person in the position of each of the parties would assume that a bargain had been concluded. Clearly not quoting exactly. There are really four main points that came, or principles that come out of this case. Three. The first principle is that pre-contractual conduct is only admissible on questions of construction of the contract if the contract is ambiguous and if the pre-contractual conduct casts light on the genesis of the contract, its objective aim, or the meaning of a descriptive term. This is consistent with a case called Cadelpha and the State Rail Authority of New South Wales, which we'll look at in some more depth in a few weeks' time. So here when I'm talking about construction, I'm talking about understanding the contract. So information that relates to the ways that the parties interacted prior to entering into a written agreement is only relevant to the point of to the extent that it points to the way that we can have a meaningful understanding of the words in that written agreement. The next relevant provision here, or relevant principle, is that post-contractual conduct is admissible to help the court identify whether or not a contract was in fact formed. If there is doubt as to whether or not there was agreement at all, and here it was not possible to point to an offer and a matching acceptance, then it's relevant to look at the conduct of the parties after the alleged contract was formed with a view to identifying objectively whether or not we can see a contract. The third principle here is that post-contractual conduct is not admissible on the question of what the contract means. So it's worth having a look at the judgment because Hayden makes some really important observations on the issues associated with applying the offer acceptance approach in the kinds of circumstances that we're exploring today. And he refers to a number of cases when he's doing so, including the McRobinson-Miller airline case. So McRobinson and the State Commissioner of Taxation in Western Australia, which we discussed at the beginning of the semester. And he points out that offer and acceptance analysis doesn't work well in those kind of circumstances. So ultimately we can find a test in Brambles, and it asks us to look at the circumstances, determine whether we can infer an agreement from the conduct of the parties, and then if we can, from the conduct of the parties post the alleged contract being made, be able to see whether mutual assent has occurred, whether both parties are acting on the basis, on such a basis that a reasonable outsider would assume that they had entered into an agreement. And ultimately that's that test. Would a reasonable person conclude that a bargain had been made? And if we could find that, then we have agreement. But clearly, if we've got an offer and a matching acceptance, that is a much easier way to address the problem. So ultimately, our framework for determining whether an agreement exists or not can look something like this. We start first by trying to identify a distinct offer which is capable of acceptance on its terms, which has in fact been accepted without variation before it was withdrawn, and that's the conventional approach. But if we don't see that, then we need to turn our minds to the question of whether the test from Brambles is useful to us. Can we look at the circumstances and see whether agreement can be inferred, whether there is a manifested mutual assent, and whether those things come together in such a way that a reasonable person having the knowledge of the parties would assume that the parties had in fact reached agreement. So that's where I'm going to leave the desk lectures for this subject. Sorry, not for this subject. Wouldn't that be nice if we were over? No, sorry, for this topic. And I'm just going to highlight here a couple of things that we will come back to over and over again. It's important in this topic to make sure that you're comfortable with the difference between a unilateral and a bilateral contract. Don't overthink it. It is an issue that confuses many people, but it's a very small issue and it will come to you. You will start to see it. You need to be able to identify what an offer is. You need to be able to distinguish an offer from other similar types of conduct, including an invitation to treat. So you need to be able to explain what an invitation to treat is. You need to be able to understand the difference between a conditional offer and an option. We also need to be able to consider when an offer can be terminated and how it's terminated. We need to be able to identify what acceptance is and understand the importance of communicating acceptance. Ultimately, as well, it's important to understand what a counter offer is and what its impact is on a negotiation, and then really ultimately come to that overview test in Brambles. So if all else fails, we have a test for finding whether or not we've achieved mutual assent. Questions, concerns, frustrations, even compliments, you know where to find me.